a distinguished judge, Robert Spano, who is the president of the European Court of Human Rights. His address today, transparency and the importance of confidence building, will also be the key direction for our discussion today, but we'll also hear about how the European Court of Human Rights hears this.
Yes, I hear you very well. Do you hear me?
Yes, of course. Thank you very much for your reference, and floor is yours. Thank you again.
Thank you very much to all the organizers, President Knežević, Mrs. Braithwaite. Thank you very much for organizing and inviting me to this online judicial forum. It is a great pleasure for me to be here with you. You have chosen an extremely interesting and timely subject matter for your forum, transparency and public access to the judiciary. You might ask, why is this timely? I would say one can answer that for two reasons. The first is we are witnessing what some commentators have called rule of law backsliding in certain European states. Recent litigation, both in my court, the European Court of Human Rights, and in the European Court of Justice of the European Union, have demonstrated, in particular on the issue of judicial independence, the growing tensions between the executive, parliament, and the judiciary. This requires mutual awareness. It requires us to be open and live to the fact that the stakes are high, which is why current challenges to the independence of our judges should be taken seriously. I'm particularly thankful and happy to share the virtual stage with my good friend, Lord Reid of the Supreme Court of the United Kingdom, because I am fully aware that his wisdom and contribution will be of immense importance for this topic. Indeed, steps taken to increase transparency and public trust in the judiciary are more relevant now than ever. The second reason why this topic is so timely, it is because the COVID-19 pandemic has led to a number of restrictions. Restriction being posed on for us on the people for sanitary reasons. Basic freedoms have been restricted, including freedom of movement. Courts, like all institutions, have had to adapt their working procedures. Now, evidently, ensuring court services and organizing public hearings has been extremely challenging for national authorities. Yet at the national and the international level, we have had to change our working practices in a variety of ways by recourse to online hearings, for example. As a result, the pandemic has accelerated a number of changes which were already in the pipeline, and I would venture to say will be positive in the long term. And I think in some ways these changes should be embraced. I'm going to proceed today in 4 parts. The first part, in my first part, I will look at ways to promote a better understanding of the work of judges within our democracy. Next, I will look at the importance of transparency in the context of the right to a fair trial under the European Convention on Human Rights. Thirdly, I would wish to set out how the Strasbourg Court has responded to the challenge of public justice through webcasting. And fourthly and finally, allow me to say a few words about justice during the pandemic, and in particular, the experience of the European Court of Human Rights. So now I turn to my first part, promoting the understanding of the role and the work of courts and enhancing public trust in the judiciary. As we all know, the judiciary is one of the 3 powers of every democratic state. An official, impartial, and independent judiciary is the cornerstone of a functioning system of democratic checks and balances. Judges, independent judges, judges that are not in fear of external pressure, are in a position to do their jobs as they are required to do, are the means by which powerful interests are restrained. They guarantee that all individuals individuals, irrespective of their backgrounds, are treated equally before the law. Justice is therefore an essential component of democratic societies and a key institution that needs to be protected. The justice system aims to resolve disputes concerning parties, and by the decisions which it delivers, to fulfill both what I would call a normative and an educative role, providing citizens with relevant guidance, information, and assurance as to the law and to its practical applications. The levels of confidence in courts' activity are not uniform, however. Adequate information about the functions of the judiciary and its role, its full independence from other state powers, can therefore effectively contribute toward an increased understanding of the courts as the cornerstone of democratic constitutional systems, as well as of limits of their activity. And I would want to focus here in particular on the axiological convergence which needs to be in place between the three branches of government. Judges' independence must be preserved not only by judges themselves, but more importantly, by all elements of state power. Judges need to be protected from external pressures, and that requires that other branches of the separation of powers understand their role, and that is imperative that judges are free to be able to exercise their function in a manner which is commensurate to a democracy governed by the rule of law. There are a number of ways to make judicial institutions more accessible to the public at large, and therefore enhance their transparency. We have seen quite a bit of that of late in very interesting formats using information technology. Public hearings, the broadcasting of hearings, visits to courts, of course, the physical visits that we so miss, at least in my court, communication and outreach activities by judges, and in particular court presidents who are taking part in judicial dialogue of the type that I am engaged in here today. I have repeatedly and publicly said that the time of closed courts, the judge being divorced from his or her community, invisible as it were, is over. Although there are natural limits so as to safeguard the integrity of the judicial function, courts must be open, transparent, and dynamic institutions, adapting to the times we live in. This has been one of the primordial elements of my mandate as president of the European Court of Human Rights, the understanding, the awareness of the need for courts to be live creatures within democracy, not to be monastic institutions which do not allow for transparency and openness in their decision-making process. With that in turn, I would now like to go to my second part. The importance of transparency in a more technical context, in context of the right to a fair hearing under Article 6, Paragraph 1 of the European Convention. The public character of proceedings before judicial bodies protects litigants against the administration of justice in secret with no public scrutiny. The Kafkaesque trial is anathema to the right to a fair trial. It thus constitutes one of the means whereby confidence in the courts can be maintained, contributing to the achievement of the aim of a fair trial. Allow me to look at the importance of public hearings, firstly in the criminal and then in the civil context, bearing in mind that the requirements of a fair trial are stricter in the criminal sphere. According to Strasbourg case law, the personal presence of an accused in criminal proceedings should be taken as the rule. An oral and public hearing constitutes a fundamental principle enshrined in the right to a fair trial. Accordingly, at first instance, there must be a tribunal which meets the requirements of Article 6. The accused has the right to have his case heard with the opportunity, inter alia, to give evidence in his own defense. hear the evidence against him, and examine and cross-examine the witnesses. However, the right to an oral hearing is not an absolute right. The principle of the right to an oral hearing in the civil context are set out in the Grand Chamber case of Ramos Nunes de Carvalho versus Portugal, a Grand Chamber judgment. The right to an oral hearing is one element underpinning the overall equality of arms between the parties to the proceedings. Dispensing with a hearing is possible, but only in exceptional circumstances. There exists a possibility to remedy the lack of oral hearing before the lower court. Concerning online hearings, one of the big challenges we have been facing in the virtual COVID environment, the court has had the opportunity to pronounce on this particular type of hearing within the context of a criminal case, the case of Marcello Viola versus Italy, which was later confirmed in the Grand Chamber in Sakhnowski versus Russia, although, to be clear, not during the pandemic. The court found that as regards the use of a video link, this form of participation in proceedings is not as such incompatible with the notion of a fair and public hearing, but it must be ensured that the applicant is able to follow the proceedings and to be heard without technical impediments, and that effective and confidential communication with a lawyer is provided for. However, recourse to this measure in any given case must serve a legitimate aim, such as prevention of disorder, prevention of crime, protection of witnesses and victims, and comply with the reasonable time requirement. The same principles will apply also in the civil context. Let me now turn to the third point that I would like to discuss, the point regarding public justice at the European Court of Human Rights. Making justice better known and more understandable has become a major concern in a large number of states. The work of the Council of Europe, and in particular the initiatives of the European Commission for the Efficiency of Justice, CEPEJ, is particularly important and useful. Attending trials is obviously a way for citizens to discover their justice system, and courts are widely open to the public. This is also possible at the European Court of Human Rights. And every year, of course not in COVID times, but every year we have had over the past decade or so, no less than 18,000 visitors come to attend the hearings held in Strasbourg at the Human Rights Building. The court's hearings are public and are mainly attended by judges, lawyers, and law students from all over Europe and well beyond. Since 2007, no less than 214 Grand Chamber hearings and 60 Grand Chamber hearings have been filmed and are visible on the court's website. This number increases every year. However, this possibility has its limits, and unfortunately, not all European citizens can travel to the court. This is why, among the means used to create and strengthen confidence in justice, there is one that has become increasingly important: the webcasting of hearings. Indeed, as early as 2007, the court had put in place a system for broadcasting its hearings. This has been thanks to a voluntary contribution from Ireland. In launching the project in 2007, my predecessor, then president of the court, Jean-Paul Costa, stated, and I quote, "Lawyers, academics, journalists, and ordinary citizens, many of whom would never have been able to come to Strasbourg to attend a hearing, will be able to follow the proceedings from their homes and offices. They will be able to see and hear for themselves the arguments advanced for and against the finding of a human rights violation in respect of some of the most sensitive issues of the day. This will bring the convention closer to the ordinary citizens whom it is intended to serve and protect," close quote. Let me just say very clearly at this point, human rights in particular have seen a resurgence of backsliding, a resurgence of critical debate vis-a-vis the concept, the notion of what constitutes human dignity and human rights. We, those of us that are part of the human rights community, and I say this to all stakeholders, it doesn't matter whether they are judges, lawyers, practitioners, academics, human rights campaigners, human rights activists, politicians who understand the importance of preserving and protecting human rights. We all have to work together to create a narrative of openness, a narrative of awareness, a narrative of understanding that the edifice of society, the edifice of public governance, the edifice of public morality has to be preserved and protected by people understanding the immense importance of human rights being protected at the grassroots level. This is an existential debate of openness and transparency, which we must all take part in openness, in good faith, and with a willingness to understand the difficulties we are facing. In this regard, the reason and the very important advantage of the system is that the hearings we are protecting and trying to promote are not only filmed, but they constitute or continue to be permanently accessible on the court's website. We want to be able to disseminate information about our work every day. The importance of this archive for many people is clear. Lawyers, judges, potential applicants, members of non-governmental organizations, and of course, the many law students interested in the court's work will all have this archive for years to come. I would also mention another important element, which I have had at the forefront of my mandate. Interaction with the press is also important for the transparency of justice. The press conference of the court is held annually in January. On this occasion in January, I presented the statistics of the past year, but I also discussed openly the major events that have occurred during this period. This year in January 2021, we for the first time had to hold a press conference in hybrid form with some local journalists present in the court's press room and many others following online. Questions were also sent in writing before the event, and they were sent during the event online. In my view, this is the way to go for the future. The press conference, which I will hold in January of next year, whether or not we are still confronted with the online epidemic, will also be done in the same manner because it simply creates more access for the media community. And courts need to be in a position to explain their work, issues that have arisen, for a mutual understanding of how we proceed. My fourth and final part, ladies and gentlemen, President Knežević, is the issue of effective communication during the pandemic. The functioning of all judicial system has been severely disrupted. That is clear. I would like to mention here the declaration on lessons learned and challenges faced by the judiciary during and after the COVID-19 pandemic, which was adopted by the European Commission for the Efficiency of Justice and sets out 7 guiding principles. I would urge all judges in the Balkans, in the Western Balkans, to have a look at these criteria. As far as the judiciary is concerned, it underlines that the continuous functioning of the judiciary and of the services provided by justice professionals needs to be ensured based on European standards. Trust in justice must continue even at a time of crisis. I will now conclude by looking at the functioning of the Strasbourg court during the pandemic. Like every domestic court, we have had to adapt to the unprecedented situation represented by the COVID-19 crisis. Several exceptional measures were taken by the court during the French national lockdown, the first period being from 16 March to 10 May of last year. Most importantly, the then president of the court, Alexander Sicilianos, extended the 6-month time limit for the lodging of an application under Article 35 of the European Convention on Human Rights, based on force majeure reasoning for 3 months until 15 June 2020 inclusive. The time limits which have been allotted in pending proceedings were also extended for a month period from 16 March, and they were also extended for another 2-month period from 16 April. Teams were put in place to ensure the continuity of dealing with requests for interim measures under Rule 39. The work was done entirely remotely. It is interesting to note that the more than 80% of the cases dealt with during this period concern COVID-19 health crisis. The European Court has been able to fulfill its public service mission during the French lockdown period by ensuring the continuity of its core activities, including the handling of urgent cases and receiving and allocating applications to the relevant judicial formations. The Grand Chamber, chambers, committees, and single judges continue to examine cases by way of a written procedure. As a result of this activity, the total stock of pending cases has thankfully remained stable. Ladies and gentlemen, as an international court, the most significant achievement has been the organization of the hearings. The court took the decision to hold online hearings with the exclusion of the public. However, we managed to ensure through the use, I would say the creative use of information technology, the public character of those hearings, which took place by video conference and which the outside world was able to watch online. This was a major technical challenge for us. A number of video conference series have taken place, 6 in 2020 and 3 so far in 2021. One more will take place indeed tomorrow morning. I know that we have had very many viewers. Thousands of views of these hearings have taken place online, and we have received very positive feedback, particularly from the national courts, who inquired about our functioning during the pandemic. The court has on many occasions emphasized the special role in society of the judiciary, which, as the guarantor of justice, a fundamental value in a law-governed state, must enjoy public confidence if it is to be successful in carrying out its duties. These are not my words. This is a direct quotation from the seminal Grand Chamber judgment in the case of Baka versus Hungary of 2016. Yet, ladies and gentlemen, ensuring public confidence cannot be left to chance. I have attempted to demonstrate that courts themselves can and should take proactive measures to enhance public trust in the institution of the judiciary. This is even more important during periods of crisis, such as the global pandemic, which has limited the public access to courts and in some cases reduced the court's functioning. Now more than ever, we have together to redouble our efforts to make sure that justice is not simply done, but is also seen to be done. Thank you very much, ladies and gentlemen. Thank you very much, President Knežević. It was a great pleasure to be with you here today, and I hope and I wish you all the best for a fruitful engagement for the rest of the day. Thank you very much.